Hello and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host today, Courtney Reigel, and I will be joined by Amy Pruett, a partner in our intellectual property practice group here at Williams Mullen. Amy has significant experience working with businesses and individuals in the entertainment industry, and today's discussion is going to focus on recent cases and some related guidance from the Copyright Office regarding the use of training data sets for AI models and how the process is impacting creators, writers, and artists in the industry. Amy, thanks for joining me today. I know AI has been a hot topic in the legal world, and this issue in particular regarding training materials for AI programs has recently garnered some attention and generated some cases.
Yes, definitely. This is a hot topic, and a lot of cases have come up recently, including the Sarah Silverman case and other cases involving artists and music publishers. And the court's decision on these cases could mean things for similar individuals who've got creative materials and books, artwork, anything that has some type of copyright rights attached to them, that there's been some allegations that there are companies like Meta and OpenAI, which are AI-based companies, to train their AI models without the creator's permission.
Yeah, so the lawsuits that comedian Sarah Silverman and her co-plaintiffs filed could be especially significant for entertainment rights holders because one of the key issues in the cases is whether the practice of training AI algorithms using copyrighted material without the owner's permission infringes the owner's rights in their works. Before we get into those cases, I think it might be helpful for us to just briefly mention some details on certain types of AI models and how they're trained and developed. And then we can get back into some details of that Sarah Silverman case that we mentioned, the current status of that case, and what that might mean for others in the industry, depending on the outcome. And then we can wrap with some comments on maybe a few other cases that are going on and some just high-level guidance from the Copyright Office and what we expect them to issue on AI shortly. So it's a little bit of background. AI software is designed using an algorithm to simulate human reasoning or inference so that the output of a program, something like ChatGPT, mimics something that an actual person would write or create. So one type of AI program is a large language model. An example of this is Meta's Llama AI program, which is the subject of one of the lawsuits that we'll discuss in a moment. And it is designed to emit natural language. Of course, if you've ever used ChatGPT or a similar program, you know that sometimes it is obvious that it's been generated by AI, but overall it is pretty impressive to see the type of output that these programs come up with. And how they get to that point is using these training data sets that are based on pre-existing materials that have been developed by humans. So these large language models like Llama are not created by human software engineers writing code like other software programs. As I mentioned, the large language model AI has to be trained by reviewing massive amounts of text that are typically compiled from various sources and that are then fed into the model. Those input materials are sometimes referred to as the training data sets. And the large language models, they copy the text in the training data sets, and then they extract information from those data sets, essentially just copying and reviewing all of the text so that it can then emit that convincing simulation of human written language. So the training process and what goes into these AI models and the training data sets is really an important part of the process in creating these programs. And a question that's coming up in the recent cases and that we think will impact the entertainment industry pretty significantly is whether the creators of AI programs like Meta can use entertainers' materials in a training data set without permission, and sometimes even having gathered those training materials from sources where, the materials might be they're pirated or they're obtained illegally, and then without providing any type of credit to those creators or compensation, or whether that process should be considered copyright infringement. So then, Amy, getting into the specific cases a bit, can you maybe give us an overview of what some of these entertainers are raising in their complaints against the creators of the AI programs?
Sure. Currently, there are several cases that are currently getting attention, and the popular comedian Sarah Silverman, as we have alluded to, and two other plaintiffs, Richard Kadri and Christopher Golden, are authors who've written books, and they are alleging that they were included in the training data sets used by OpenAI, the creator of ChatGPT, and by Meta for its Llama AI program. In one of those cases, Silverman and her co-plaintiffs filed a class action lawsuit earlier this year, alleging that they didn't consent to the use of their copyrighted books as training materials for the Llama program. In the complaint, the plaintiffs state that Meta describes the Llama training dataset as a large quantity of textual data that was chosen because it was publicly available and compatible with open sourcing. However, copyrighted materials are not typically compatible with open sourcing unless the materials are already in the public domain or the copyright owner first makes their material available to the public under an open source license. So the plaintiffs also allege that at least one of the sources that Meta used to gather text from books for its training set and how they believe the text of their books was acquired was this notorious shadow library website that aggregates books in bulk. These shadow libraries have long been of interest to the AI training community because of the large quantity of copyrighted materials that are available. But the shadow libraries also are considered flagrantly illegal by those copyright owners. So as mentioned, the plaintiffs believe their books that were included in the dataset to train Llama were obtained by Meta from one of these shadow libraries. So far, Meta's made Llama selectively available to organizations that request access for non-commercial use for research cases. And that access to the model will be granted on a case-by-case basis to academic researchers and those affiliated with organizations in government, civil society, academia, and industry research laboratories around the world. However, Meta has not disclosed what criteria it uses to decide who is eligible to receive the Llama language models, nor has it actually received them, or whether Meta has in fact adhered to its stated criteria. In the complaint, the plaintiffs allege that Meta has in fact distributed the Llama models to certain people and entities and has benefited financially from doing so, and that in March 2023, the Llama language models were leaked to a public internet site and have continued to circulate. The plaintiffs also note that Meta reported plans to make the next version of Llama commercially available. So the issue of how the AI program is being used, whether commercially or not, is relevant because it raises issues whether use of the owner's copyrights is considered fair use. The plaintiffs hold the exclusive rights to their books under U.S. copyright law and never authorize Meta to make copies of their works, make derivative works, or to publicly display or distribute copies of their works or of derivatives. So these are some of the exclusive rights under copyright laws. And the plaintiffs allege that Meta made copies of their works during the training process of the Llama language models without plaintiff's permission. Now, plaintiff raised several counts in the complaint, including direct copyright infringement based on the fact that Meta made these copies of their works without their permission. And they've included counts of vicarious copyright infringement, stating that Llama's output should be considered an infringing derivative work because it and the model itself is based on their underlying works that were included in the data set, as well as counts stating that their copyright notices were removed from their books when they were just incorporated into the training materials, as well as claims of unjust enrichment, negligence, and unfair business practices under California law.
Thanks, Amy. So there have been some recent developments in that Sarah Silverman case. And so if you could just maybe give us an overview of where we are now in the plaintiff's case against Meta.
Yep. On November 20th, the judge dismissed the bulk of those counts in the lawsuit, but did give Silverman and her co-plaintiffs the opportunity to amend and refile most of their claims, except for the negligence claim, which was preempted by copyright claims. And this motion was granted as to all the claims except for the claim for direct copyright infringement.
Okay, so we'll have to wait and see how the case proceeds with regard to that kind of leftover claim for direct copyright infringement, which that centers on this issue of whether the creators of AI programs can use entertainers' materials without permission to train their AI models. And I think it's worth briefly mentioning that there's another case involving different underlying materials, but a similar fact pattern, and it's at a somewhat similar stage in the process right now. So the case is Anderson versus Stability AI Limited. It's also currently in U.S. District Court in California. And the plaintiffs in that case are several visual artists, and they have filed suit against Stability AI and several other defendants alleging that their artwork was used to train some different AI image generator programs. So this is a different type of an AI program than the large language model, but that still needs to be trained using pre-existing materials. And the plaintiffs are saying that the defendants' use of their artwork in those training sets infringed their copyrights. The plaintiffs also had included in their complaint against Ability AI that the output of the image generator AI program that is based on their work is also infringing. Those counts were similar to what the plaintiffs in the Sarah Silverman case had raised about the output of the large language model being an infringing derivative work. But similar to the Silverman case, at the end of October, the judge in the Anderson case threw out all of the plaintiffs' counts except for their claim of direct copyright infringement. So it looks like that is going to be the primary issue and remaining claim in both of these cases.
Yes. Also in the music world, there have been several music publishers who filed a lawsuit against the Amazon-backed AI company Anthropic, alleging that it also improperly used thousands of lyrics and musical compositions from what they called some of the most popular songs of all time without permission to train its AI program. Anthropic recently filed a motion to dismiss or to transfer venue from Tennessee, where Anthropic filed, and saying it does not target businesses, or saying that Anthropic does not target businesses in Tennessee. So we don't have a clear picture yet on how the court will rule in these cases on some of the substantive issues like copyright infringement and fair use for training purposes.
So I think the end result here obviously could have a large impact on creators in the industry and how their content can be used in connection with the training of AI models without their permission, without compensation. And then as a final topic for today's discussion, I just wanted to briefly touch on the Copyright Office's stance on this issue. As we mentioned, AI has obviously been a very hot topic. Earlier this year, on November 15th, the U.S. Copyright Office's General Counsel, Suzanne Wilson, addressed an audience at a conference in California where the topic was the intersection of technology and entertainment, mentioning that the Copyright Office expects to issue a major AI report soon. And she specifically mentioned that the Copyright Office has been seeking public feedback on AI issues and anticipates releasing their report in 2024.
We'll certainly be looking forward to that report, and it's worth noting that her comments follow the Copyright Office's earlier announcement that it's considering an exemption to copyright protection laws that would allow researchers looking into artificial intelligence bias to bypass some of those technological measures that control access to copyrighted materials. So the measure would allow researchers to access copyrighted generative AI models. As a reminder to listeners, software programs can also be protected under copyright law. The Copyright Office is also considering another new exemption to federal copyright law that are not necessarily related to AI.
Thanks, Amy. With that, I think we will wrap up our discussion on AI and its potential impact on entertainers, including creators, writers, and artists. We'll look forward to seeing what comes out of these cases, as well as the Copyright Office's report and what potential exemptions might come out of that. And we'll keep our clients and listeners updated on the same. Thank you again, Amy, for joining me today and providing this information to the listeners of Trending Now, an IP podcast. Listeners, if you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. And thanks for listening. And until next time.